while the trial continues in the courtroom, witnesses must wait here in the witness room. Witnesses may have to wait a long time before they are called to give their evidence, and while the court is in session, they must remain in the witness room. Like jurors, witnesses can claim travelling expenses and an allowance for any loss of earnings. It's important that witnesses do not discuss the case with each other, as they may be asked about this in court. This may lead the jury to doubt the evidence that they give. Until they have given their evidence, witnesses are not allowed to see or hear any of the trial, as this may influence the evidence that they give to the court.
No further questions for this witness, my lady.
That's all, Mrs. Jenkins. You're free to leave the court or take a seat at the back as you wish. Thank you.
Once the prosecution and defence teams have no more questions for a witness and they have finished giving evidence, they may join the members of the public in the gallery to watch the rest of the trial. Witnesses, such as the young boy, may want to bring someone to court to sit with them, but his mum will not be allowed to go into the witness box with him. Children often find the experience of giving evidence very difficult and traumatic. The court does its best to make children feel as comfortable as possible.
Yes, Mr. Dalrymple, your next witness.
My lady, my next witness is number 3 on the indictment, Aaron Matthews. My lady, this witness is 11 years old. I have discussed the court arrangements with the witness and his mother, who he has brought along as a support person, and he has decided to sit at the table. And I would be obliged if the court officials could remove their gowns and wigs, my lady.
Yes, very well, we'll do that, and we'll bring him in and he can sit at the end of the table here.
I'm obliged, my lady.
Very well.
In some cases, the sheriff may ask all members of the public to leave the court.
Now, Aaron, have you been here all day waiting to get in this court, have you?
Yes.
And what age are you?
I'm 11.
You're 11. When was your birthday?
The 27th of August.
Of August. And so, Aaron, have you got the day off school today?
Yes.
Yes. And do you have to go back after you've given evidence, or are you off for the whole of the day?
I think I'm off for the whole day.
I see. And what is it you want for Christmas?
A mountain bike.
A mountain bike? Do you not want your mum to take you to see the new Harry Potter movie? Have you not seen it?
No.
But you know it's full of magic, don't you?
Yes.
And you know the difference, do you, between magic and what's real?
Yeah.
And you know the difference, do you, between telling lies and telling the truth?
Yes.
Right. Well, can I tell you that in this court you have to tell the truth? You understand that? Mm-hmm. Now, your mum's sitting in the back row there behind the dock, and she's here to support you, all right? And what does she do to you if you don't tell her the truth?
I get grounded.
So do you tell her lies often or not very often?
Not very often.
Not very often, because you don't want to be grounded too often, do you? Mm-hmm. Right. Now, this lady here is going to be asking you questions about what happened on a day in June last year, all right? It's very important that you answer her truthfully. You understand me? When she's asked you some questions, Mr. Scott, this is the man sitting facing you, he might have some questions to ask you as well, and you must answer him just as truthfully. All right?
Yes.
Now, if you want a break, will you let us know and we'll arrange to have a break for you? And if you want a drink of water, just let me know. All right? Okay. Yes, Mr.
Obliged, lady. So, understand that your full name is Aaron Matthews?
Yes.
Right, okay.
As with all prosecution witnesses, Aaron will first be asked questions by the Crown and then cross-examined by the defence solicitor.
Was there anyone else in the queue?
Yes.
Right. Do you know how many other people there were in the queue?
I'm not sure.
Right. Okay. And did something happen?
Expert witnesses and police officers are treated the same as the other witnesses. They too are asked detailed questions. However, because a police officer may deal with a number of incidents every day, it may be difficult to remember exact details about a particular case, so they can ask to refer to their notebooks.
Could I refer to my notebook?
Did you take the note at the time?
I did.
Yes, very well.
I suggest to you, officer, that your evidence is nothing but a tissue of lies. Is that not the case?
That's not the case.
And you would have said anything today to get my client convicted, wouldn't you?
That's not true.
And no further questions, my lady.
Miss Dalrymple.
I have no further witnesses for the Crown, my lady, and I formally close the Crown case.
Ladies and gentlemen, the Procurator Fiscal has closed the Crown case. That means that you've heard all the evidence that she proposes to lead before you in relation to this charge. Mr. Scott, what's your position?
At this stage, my lady, I would indicate that I have a submission of no case to answer, which would clearly require to be heard out with the presence of the jury.
Often at this stage in the proceedings, the defence solicitor makes a submission to the court that there is no case to answer. If this happens, the jury are asked to return to the jury room so that the sheriff can hear the legal arguments from the defence and prosecution.
Yes, Mr. Scott.
Right. Yes, my lady. The situation here is that, so far as sufficiency is concerned, I have some problems. I think there may be a technical sufficiency, but I don't think that the evidence marries up in a way that would entitle the Crown to get beyond this stage.
Basically, the defence is trying to convince the sheriff that the Crown has not brought enough evidence to prove that the crime was committed by their client. If the sheriff agrees with the defence argument, then the trial will be stopped and the accused acquitted. If the sheriff disagrees with the submission, the jury is brought back into the courtroom and the trial continues. And the defence can begin to call defence witnesses. But remember, the defence does not have to call witnesses to prove that the accused is innocent. The prosecution must prove beyond reasonable doubt that the accused is guilty.
I have no hesitation in repelling it.
Once all the evidence has been given, the fiscal and the defence solicitor start their closing speeches, talking directly to the jury.
Ms Dalrymple, can I ask you to address the jury on behalf of the Crown, please?
This is the last chance to remind the jury of the evidence that has been presented.
Ladies and gentlemen, it now falls upon me, as the Procurator Fiscal Depute, to address you about the case and the evidence that we've heard and seen over the past few days. Finally, ladies and gentlemen, I would ask you to consider all the evidence in this case very carefully and the points that I've made in relation to it. I would invite you, ladies and gentlemen, to convict the accused of the charge on the indictment. Thank you very much for listening.
Mr. Scott, can I invite you now to address the jury on behalf of the defence?
It also gives the defence team an opportunity to challenge that evidence and to question the reliability of Crown witnesses.
In this case, as in every other criminal case in our courts, the starting point for you is that my client, the accused, is presumed to be innocent of this charge. And that doesn't change unless the Procurator Fiscal satisfies you beyond a reasonable doubt is that his evidence was wholly unsatisfactory and not good enough to assist the Crown in seeking to convict my client. In all the circumstances, I would invite you, ladies and gentlemen, to accept that there is a reasonable doubt left in this case, and in those circumstances to acquit my client. Thank you for your attention.
After the closing speeches, the sheriff will address the jury. This is called charging the jury. During this speech, the sheriff tells them of the laws that apply to the case and reminds them of their duties as jurors.
Ladies and gentlemen, you've now heard all the evidence, the speeches for the Crown and for the defence. At this stage, I have to explain the legal rules that are relevant for deciding this case, and you must accept these instructions in law from me and apply them to the facts in reaching your verdict. There are 3 verdicts open to you: guilty, not guilty, and not proven. Not guilty and not proven are entirely the same. They're both verdicts of acquittal. In each case, the accused would walk free, never to be tried again. In effect, they are identical verdicts. If you propose to return a verdict of guilty, can I say that at least 8 of your number must be in favour of that verdict? You decide which witnesses you believe and which you disbelieve. You decide which witnesses you find reliable and which are not. You can look at the content of the witness's evidence, and you can also take into account their demeanour or their body language when they're giving their evidence. Doing that and comparing what each witness says with other evidence in the case can help you to assess the credibility and the reliability of each witness. You can also test their evidence by plain common sense. Ask yourself, does their evidence ring true? Reach your verdict, ladies and gentlemen, on the basis of the evidence and the reasonable inferences or deductions or conclusions that you can draw from these pieces of evidence. Don't speculate, don't guess. And ladies and gentlemen, don't be swayed by emotional considerations or any prejudice. Put sympathy aside. Your function now is a judicial one, and you have to approach the evidence impartially. Ladies and gentlemen, can I ask you to retire now? Please don't rush to your verdict. Take your time in your deliberations. It's clearly an important matter for the Crown, who represents the public interest, and it's an important matter for the accused. I'll ask you to retire now, and if you let us know when you've reached a verdict. Thank you.
The jury now returns to the jury room to consider their verdict. One of the first things that the jury must do is to choose someone to be foreman or forewoman.
Okay, well, we're going to have to appoint a spokesperson. Does anyone really particularly want to do this, or no? What about you?
Well, if nobody else wants to do it.
This juror will be in charge of the discussions inside the jury room and will speak for the jury when they return to the courtroom. There are no fixed rules or procedures about how the jury discuss the case or reach their verdict. Each jury will conduct itself in a slightly different way. The jury can take as long as it needs to discuss the case and to reach a verdict. In some cases, it may even be necessary for the jurors to stay in a hotel overnight rather than return home. To help them during their discussions in the jury room, the jury can refer to any notes that they have taken or request to see copies of productions. Whilst in the jury room, jurors are not allowed to leave or to contact anyone, and no one except a court official is allowed to enter. At mealtimes, the court will provide refreshments. For a verdict to be given, a majority of the jury must agree. A majority is always 8, even if due to illness a juror has left the trial. Whilst the jury deliberates, others involved in the trial await its verdict. As we said earlier, when considering a verdict, the jury are not allowed to leave the room, so they communicate with officials of the court by pushing a buzzer or a bell or by knocking on the door. Everyone now assembles to hear the verdict of the jury.
Ladies and gentlemen, have you elected a spokesperson, and if so, will that person please stand? Have you reached a verdict?
Yes.
What is your verdict in respect of the accused?
Guilty.
Guilty. Is that by majority or unanimous?
By majority.
If you have a seat just now, please, and I'll record the verdict. Ladies and gentlemen, is your verdict properly recorded as follows? The jury, by majority, find accused guilty as libelled. Thank you.
Having delivered their verdict, the work of the jury is done, and the case now moves on to stage 4, sentencing. The fiscal and defence lawyer make recommendations to the sheriff on what the sentence should be.
Ms Dalrymple?
Lady, in light of the jury's verdict, I formally move the court for sentence. There is nothing libelled in respect of this matter.
No previous convictions?
No, my lady.
Thank you.
The fiscal will tell the sheriff of any previous convictions, if there are any, and the defence solicitor will give some background information about Darren.
Thank you. Mr Scott?
The jury has convicted my client of clearly a very serious charge, but he is only 19 years of age.
When deciding what sentence to impose, the sheriff has to take into account both the facts of the offence and the circumstances of the offender. The sheriff has a number of sentencing options that she can impose, some of which include a fine, community service or imprisonment.
I invite your ladyship to allow him to remain on bail in the meantime, with all options being kept open.
Yes, thank you. Stand up, Mr Ballantyne.